Hi, my name is Zak Goldstein. I'm a criminal defense attorney in Philadelphia, and today I'm going to talk about receiving stolen property, which is a very common theft offense that you might see in state or municipal court, either in the Court of Common Pleas or the Philadelphia Municipal Court. Receiving stolen property generally gets charged when the police arrest the defendant and the defendant has something in his or her possession that doesn't belong to them. There's typically two elements to that charge. It's either the two elements are that one, the defendant possessed property that was stolen, meaning someone has reported property stolen, or someone's going to come to court and say that item belongs to me, the defendant shouldn't have had it. And then it's not enough just for a defendant to have something that's stolen. There's a second element to receiving stolen property, which that the defendant knew either that the property was in fact stolen or the defendant believed that it was probably stolen. Either one is enough. So the key to receiving stolen property is it's not enough just to have something stolen. The defendant has to know about it, or at least has to have a pretty good idea that they've taken something that doesn't belong to them. Receiving stolen property in state court can the severity of it can really vary because it can be a felony or it can be a misdemeanor. It becomes a felony when the property is worth more than $2,000. And below that, then there are varying levels of misdemeanors that receiving stolen property can be charged as if you get arrested and charged for that type of theft offense. So the value of the property is incredibly important because, especially if you have no record, for someone who's dealing with property worth more than $2,000, or when it's a car or motor vehicle, boat, motorcycle, doesn't matter what type of motor vehicle, but anything $2,000 or more, or a motor vehicle is going to be charged as a felony, which makes it more likely that the defendant could end up with a felony record or could end up with some potential jail time. But fortunately, there are defenses to receiving stolen property. Like any charge, someone who is charged criminally with receiving stolen property in Pennsylvania is typically going to have a preliminary hearing first, where it may be possible to get some or all the charges either reduced or thrown out. And then even if a case makes it past the preliminary hearing, then every defendant has a right to a trial with a jury where the prosecution has to prove that the defendant had stolen property and knew that it was stolen or believed it was probably stolen beyond a reasonable doubt. In terms of challenging receiving stolen property charges, whether it's at the preliminary hearing or whether it's at trial, one of the most common defenses is going to be that the defendant didn't know it was stolen. And this comes up a lot in cases involving stolen cars, stolen dirt bikes, even a stolen laptop purchased off Craigslist, something like that. It can be a defense if you borrow a friend's car or borrow a car from somebody and get pulled over in it and it turns out to be stolen. You're not automatically guilty of receiving stolen property. There are factors called the Mathews Factors that the court is typically going to look at, whether it's a preliminary hearing or that a jury would be instructed on, that they can consider in determining whether or not the defendant actually knew that the property was stolen. And some of those factors are going to be, first, how much time has passed between when the property went missing and when the defendant was found in possession of it. If you've got property that was stolen 5 minutes ago, then the odds are higher that you knew that it was stolen or had something to do with stealing it. If it was stolen a few days ago or weeks ago or a year ago, then the odds are greater that the property changed hands and you could have bought it from someone who claimed that they owned it legitimately. Other things that they're going to look at in a car case, for example, at a preliminary hearing, a judge could look at, is there damage to the ignition? Is there damage to the locks or the windows that suggest that this defendant should have known or knew that they were driving a stolen car? If you're driving the car that you've hot-wired and there's a screwdriver sticking out of it and that's how it's being operated, then the evidence is pretty good that the car was stolen because you don't have the keys. But at the same time, if the car was stolen a couple days ago and there's no damage to it and you've got the keys, then they may not have enough evidence to prove that the car was stolen and that the defendant knew that it was stolen. There's two other main factors. The third one is whether or not the defendant does anything suspicious to indicate that the defendant knew that the property was stolen. If it's a stolen car, it was stolen yesterday, and the defendant runs away from the police, or the defendant gets stopped with stolen property and tries to throw it on the ground and then run away, then that's going to be evidence that the prosecution could use to show that the defendant knew the property was stolen. And then the fourth is going to be, did the defendant cooperate with the police? Did the defendant try to provide a reasonable expectation? In the Mathews case, where the factors come from, the defendant explained the defendant had borrowed the car, had traded for it. And so those are some of the factors that a court's going to look at in deciding whether or not a defendant knew or probably knew that the car or other property in question was stolen. So there are defenses. A misunderstanding could be a defense. Genuinely believing that you purchased or borrowed or rented legitimate property, and then it turned out that you got defrauded, that you were a victim of a crime, that's a defense to receiving stolen property charge. Challenging the gradation of the stolen property, or challenging the gradation of the charge could be a defense. If someone says $2,000 worth of jewelry was stolen, making it a felony, but it turns out that having an expert witness come in to appraise it can mean that the jewelry is not worth $2,000. That could be a defense that gets it down to a misdemeanor. And then there are often other options. If the defendant doesn't have a prior record, there may be pretrial diversionary programs like ARD or the accelerated misdemeanor program that could allow for paying restitution or returning the property without a conviction or a finding of guilt that stays on the defendant's record. There may be other defenses. Every case is different. There could be constitutional defenses like a motion to suppress if the police did something illegal to find the evidence. Or there could be other defenses like a speedy trial motion if the case drags out for too long. But the key point is that the prosecution has to prove both of those elements beyond a reasonable doubt. And if they can't do that, then that could be a defense at a trial, and it might even be a defense at a preliminary hearing. Now, we've handled probably hundreds, thousands of theft and receiving stolen property cases involving stolen cars, stolen electronics, stolen jewelry. And our criminal defense attorneys offer a free 15-minute criminal defense strategy session if you're facing criminal charges or potentially under investigation. So give us a call at 267-225-2545 to speak with a criminal defense attorney today.